Hey, thank you, Kelly. Next slide, please, Vic. All right. I'm Bob Damewood. I'm a staff attorney with Regional Housing Legal Services. And I'm hearing an echo. I don't know anyone else. Is everybody muted?
Kelly's not muted.
Okay. All right. Hey, okay, echo gone. Again, I'm Bob Damewood. I'm a staff attorney with Regional Housing Legal Services in the Pittsburgh office. We're a statewide specialty legal aid program that primarily engages in or provides transactional legal services to community-based nonprofits in housing and community development transactions that benefit low-income Pennsylvanians. I'll be joined by Dan Vitek. He is a staff attorney with the Community Justice Project. They are a statewide, except for Philadelphia, specialty legal aid program that engages in impact litigation on behalf of low-income Pennsylvanians. Eileen Yacknin is litigation director with Neighborhood Legal Services here in Pittsburgh. They are a legal aid program, a geographic-based legal aid program here in Pittsburgh and surrounding areas. And then we'll be joined by Kadeem Morris and Vikram Patel. They're both staff attorneys with Community Legal Services in Philadelphia. Next slide, please, Vic. And so today we have a lot of material to cover today. Kadeem is going to provide an overview of the various moratoriums and filing requirements and restrictions that eviction cases are operating under in Pennsylvania. Dan and Eileen are going to cover affirmative defenses to eviction cases, under those laws. Let me see. I believe I could be wrong, but I believe Vic is going to discuss payment plans. If I'm wrong, please correct me.
I think Eileen's going to hop on that one. And then I was going to hop in on the affirmative claims section.
There you go. Okay, I should not have covered this slide. All right, thank you. And then I and Vic are going to cover some general issues around resources. So, especially rental assistance, what rental assistance is available during this time. And so let's get started, and I'll hand it off to Kadeem.
Kadeem, you might be muted.
Yeah, I had to wait for the host to unmute me. Apologies to everyone. Good morning. As Rob said, my name is Kadeem Morris. I'm a staff attorney here at Community Legal Services Philadelphia, and I'm going to get started with introductory information to kind of frame our conversation. Next slide, please, Vic. So as you hopefully are all aware, most of us are working remotely due to COVID-19. And as a result of that, the PA Supreme Court issued a judicial emergency. That was issued back on March 12th of 2020, which is this year, and it essentially expired on June 1st. But what the Supreme Court did, and during that period, landlords weren't allowed to file, courts weren't open, most statutes or notice requirements were tolled for the period of the judicial emergency. What the Supreme Court did in their order that essentially ended the judicial emergency was that they carved out the power for lower court judges, i.e. your county president judges, Commonwealth Court judges, to have their own judicial emergencies that extended beyond the period of the judicial emergency that existed statewide. So for instance, Philadelphia had a judicial emergency before the Supreme Court put their judicial emergency in place, and it still is continuing and goes through, I believe, the first week of September. Additionally, the courts were empowered to suspend and modify their operations. So courts that may not have necessarily done a full judicial emergency have decided to cancel in-person hearings and do most things via remote Zoom as we are now. Some courts have also canceled in-person jury trials. There are different ways in which courts have modified their operations during this time, included but not limited to toll and notice statutes and pushing out deadlines for filings that would otherwise have occurred during the period when the courts weren't operating fully. So that we know of, I believe Mifflin County, Allegheny County, Philadelphia, Delaware, and I believe there's one more. There might be an order in Lehigh County that I need to confirm. It's not included in the slide. But those counties each have their own judicial emergency that either ran concurrently or still running right now. So if you are operating in the county and you're unclear as to what the status of your courts are, check to see if your precedent judge issued an order that pushes the court out or modified filing requirements because you may have more time to necessarily file a response or an answer. Most importantly, landlords should not have been able to file eviction cases during this time period, so that is something that you may also want to check for. So, as we are aware, hopefully, the governor enacted an executive order that essentially prevents landlords from filing evictions during the period when the order runs. It has a carve out for breach cases, so it's not a total moratorium on eviction, but it's a qualified moratorium, so a landlord can't file on the basis of non-payment or termination of term. The moratorium through executive order was enacted on July 10th, well, the most recent one was enacted on July 10th and expires on August 31st. And what the governor did, since, separation of powers, independent arm of the state, he suspended the notice provisions for both foreclosures and evictions. So essentially, a landlord is required to provide notice in most instances to file an eviction to evict a tenant from a rental property. Once the statute is suspended, the landlord cannot file notice, cannot give the tenant notice, and therefore cannot technically file in court. Now, there are leases that do waive the notice requirement between the landlord and the tenant. So that is something to look out for in terms of when you're raising the defense of can the landlord actually file this case. You should not be able to file unless it's a breach case or unless there's a particular waiver in his lease that allows him to file. Additionally, as we talked about, local court ordinances and local rules may also modify the filing requirements and the landlord's ability to file. So if you're, for example, not to return to Philadelphia, but Philadelphia recently passed the Emergency Housing Protections Act, which essentially extends the COVID-19 emergency period in the city through August 31st. And it also limits the ability of landlords to file cases without taking certain steps through the city. So if there's a local ordinance that affects your landlord's ability to file, even if they may not be captured by the governor's executive order, there's another layer that you should look at before deciding whether or not the case has been validly filed. And I think Eileen and others will talk about preliminary injunctions later in the presentation. So we can go to the next slide. So the CARES Act, as I'm sure everyone is aware, it is a federal piece of legislation, and there is about a paragraph or so that talks about housing. It was enacted in March, and technically the act itself, or the protections, most of the protections under the act ended on July 25th of 2020. There was a 120-day window, call that an eviction moratorium for federally subsidized properties or properties where the owner has a federally backed mortgage. The things that they could not do during this period are landlords could not collect late fees for rent that wasn't paid. They could not send a notice to vacate or notice to quit, which is an eviction notice. And they could not initiate a filing to recover possession, i.e. evict someone within that time period. At the end of the 120-day window, which ended on Sunday, landlords technically to evict someone would be required to send a 30-day notice that basically informs the client that they are going to start an eviction proceeding. Again, to go back to the example of Philadelphia and the Emergency Housing Protection Act, if there is a local law that tolls that statute, or the governor's law, the governor's executive order that pushes out or suspends the ability of a landlord to send a notice, the notice cannot be sent until that executive order expires or local ordinance expires, because the CARES Act requires that any notice sent to a tenant also has to comply with local and state rules around notice provisions. So I'm going to turn it over to Vic, and he will go into some more depth about the CARES Act.
Sure. So because a lot of people have heard about the CARES Act, I'm gonna move through these next few slides fairly quickly, especially because we have we've already passed the expiration of the moratorium, even though we still have some protections still left. So first, who's covered? So there are essentially two broad categories of dwellings that are covered. First category is federally subsidized housing. So this can take several different forms. We have a list here. It's not necessarily an exhaustive list. There may be some that aren't covered in it, but essentially if the tenant or the landlord has to submit some sort of certification in order to get a subsidy, or they're getting a subsidy from the federal government, then the CARES Act applies. So this is some of the most common ones are Section 8 housing choice vouchers, or LIHTC properties, or just plain old public housing. So yeah, first category, federally subsidized housing. Second category is the much more sort of broad one and more amorphous, the harder one to figure out, which is a federally backed mortgage. So one of the reasons why this is can be so hard to figure out is that we have HUD, USDA, FHA mortgages, and those you may be able to get that information as an attorney representing a tenant. You may be able to get information on whether or not a property is covered by one of those by pulling the mortgage. On the mortgage it should say. But the other two, Fannie, properties that are covered by Fannie Mae and Freddie Mac, this is much harder to figure out. Now there are some tools that you have at your disposal to try and figure out whether or not a property is covered, and I think Dan and Eileen are going to be covering those a little bit later. But yeah, essentially this is probably where a lot of the issues with regard to the CARES Act are gonna come up. Whether or not a property is has a federally backed mortgage that brings it into being covered by the CARES Act. And even though we don't have the specific numbers for Pennsylvania, we do know that at least nationally, the Urban Institute did a study, and they see that it's there are a lot of units across the country that are covered by the CARES Act. Right, we can see that nearly 30% of all rental units are covered. But then when we look at say like multifamily units, it's nearly half. So and once again, I think Dan and Eileen will be getting into this a little bit later. When you have a new eviction filing, this is one of the first things you should look into, especially with the new affidavit requirements that will be covered a little bit later. So first, is it a covered dwelling, which we just went over, and Dan and Eileen will be going over a little bit later. Kadeem mentioned a little bit earlier, right, that the moratorium was just for non-payment cases, but that's not necessarily also the case for the notice requirement. So we can see that the 30-day notice doesn't have this question about non-payment. So some of these questions right here, these are, when we're looking at a CARES Act case, are sort of the steps to go through to see was the CARES Act complied with? And most importantly also is this affidavit. But speaking of moving into Dan and Eileen and how they're going to expand on these topics, I think we're going to pass it over to Dan and Eileen. Unless Kadeem, do you have anything else to add?
Okay, while we wait, we had a question come in, so I'm going to read it to you. I'm not sure who answers, but what happens if there's a non-payment of rent and other breach or breaches of the lease alleged? Does the governor's moratorium still apply?
Oh, I think Eileen, it looks like she wants to answer. I think she's muted. There we go.
Oh, good. Okay. Our analysis is that, first of all, the governor's moratorium applies only to the non-payment of rent moratorium, it's prohibition. So if there was a lawsuit that was filed that alleged both, then the cause of action for breach based on a non-payment of rent cannot proceed. It can be dismissed. But there's nothing that under the governor's moratorium or the federal moratorium that prohibits a landlord from proceeding with the non-payment of rent, with the non-rent breach allegations.
Yeah, so I mean, we'll address that question as we go through discussing strategies for raising these defenses. But Eileen summed it up quite well, that it's really part of the claim should be able to proceed and the other part should be dismissed.
Thank you. That was all the questions we have for now.
Okay. Well, then let's move on to talking about the defenses that have been created by the pandemic-related protections for tenants. We're going to cover prematurely filed cases, improperly filed notices to quit or no notice at all, illegally charged late fees, and failure to prove that the CARES Act does not apply. All right, so actions filed prematurely in violation of the various stays and moratoriums, either by statute or order of court or governor's executive order. Let's start with the governor's emergency executive order, which is still in place and currently runs through August 31st. That's based on the extension from July 9th. So as we just discussed, this order has been in place since May 11th, when essentially the Supreme Court allowed eviction cases to begin to proceed again. And the thing I want to clarify about the governor's order is that it has been interpreted, I think, slightly differently than what the plain language of the order itself says. And what I mean by that is that the Attorney General's office and an attorney with the AOPC has taken the position that the governor's order only applies to the notice requirements when notice has not been waived. So we're talking about cases that deal with non-payment of rent and end of lease term, and where a notice to quit was required to be provided. Now that does still cover a lot of cases, because any oral lease is going to require a notice to quit under the Landlord-Tenant Act. And also all subsidized housing and voucher holders have the requirement that notice be provided. But it also excludes a lot of cases that I think when you initially read that order, or when you read the press releases that the governor has issued around his order, you might think that it covers cases more generally. So go ahead, Eileen, you can jump in.
Well, if you go back, so the one thought about how to address a lawsuit against in an eviction case against the tenant where the lease waives the notice to quit is to attempt to assert that that provision is unconscionable and therefore not enforceable. There has not been a lot of cases in Pennsylvania about unconscionable provisions in contracts, but one case cited, Bain versus Smith, did deal with a lease issue that is possibly helpful. In that case, also dealt with another onerous provision, those provisions that impose attorney's fees in that particular lease, imposed attorney's fees on both litigants, for the prevailing party to obtain attorney's fees. And that provision was challenged as unconscionable. And ultimately the Superior Court in that case said that that was not an unconscionable provision because it was reciprocal, the attorney's fees provision, which then it did not address the question of whether the one-sided attorney's fees provision would be unconscionable, but the court also laid out the factors which would lead to a decision of determination of unconscionability, which I think we could, if we remember from law school, and also just easily from the fact that we represent tenants who are desperate for housing and don't have any bargaining power essentially in what is provided in their leases, that we sometimes argue that our tenants are not as educated as at least as the landlords. We could try to make those arguments, and if that provision were unconscionable, then it could be argued that the governor's moratorium were to apply. It's worth a shot.
Yeah, and this is a good example of what sort of the concept of how do you challenge a violation of the governor's order. So you know what the governor's order applies to, and you're gonna check the complaint to see if they said that they served notice to quit, or if they said it was waived. And if it was waived, you're gonna check the tenant's lease to see if it truly was waived. So if the governor's order applies, but the court has accepted the filing, our position is that there's really nothing that the governor or the attorney general's office is going to do to say to the court, you can't accept these filings. And the general idea that courts can't offer legal advice by accepting or rejecting filings based on the content, it's going to apply. But you certainly can raise it as a defense. And I guess it's a question of whether it's an affirmative defense or it's part of the landlord's burden, their case in chief, to present that they are not violating the governor's order. And we're going to urge everyone that we as legal aid attorneys and tenants' rights advocates take the position that this is an affirmative duty, both in the governor's order and the CARES Act and the other moratoriums, that the landlords have to show that they're not in violation of the law. And if they don't, the case should be kicked out. If they don't meet that burden, the case should be dismissed. But when we talk about taking a case out because of an unconscionable clause, that's clearly an affirmative defense. You have to allege facts that aren't part of the case in chief, and you have the burden of proving those facts are true. That the person who is affected by the unfair clause had bargaining power that was less than the drafter, that they had some reason they had to enter into the contract regardless of the bad terms, things like that. So that does present a challenge in magisterial district court where you're going in and you maybe don't have as much time to prepare with your client and lay out the facts of why they signed such a lease and what their conditions were. But I advocate and I urge the attorneys here on this training to make those arguments. And then in particular, to take it on appeal to the Court of Common Pleas, where you can lay it out in a new matter and assert it there. I do think that before the magisterial district judges are going to pick up on this and, agree to to kick out cases where a lease waives notice, but it's unconscionable, they're going to have to see some case law on it. And so that's our job, to take on that task and try to find a case with good facts that we can push and get a judge to write an opinion on.
Dan, quick question. So you said in the case of the governor's executive order, these issues should be raised as a new matter, not as a jurisdictional matter. I'm curious about, under the CARES Act, with the new requirement that there be an affidavit attached to the complaint. Should that be raised as a new matter, or is it jurisdictional and should it be used to dismiss?
Okay, sorry if I was unclear. I don't think it should be, I don't think it needs to be raised as a new matter. I don't think it needs to be an affirmative defense. If the landlord's action was filed in violation of the governor's order, the CARES Act moratorium, or any other requirement that prohibited the filing of landlord-tenant complaints, I think that is the burden of the landlord to show that they are not, that they're not covered by those rules. So let me make that clear, that when you go into a magistrate office to defend your tenant, we should be taking the position that the tenant doesn't have to offer evidence that the act or that those rules apply, that the landlord has to offer evidence that they don't apply. Go ahead, Eileen.
I was just going to say, on the other hand, for practical litigation purposes, it's not going to matter so long as the tenant and the parties are in proper litigation status, meaning at the magistrate's hearing, it's not really going, you can say, oh, it's the plaintiff's burden to prove, and they didn't prove it. And if the magistrate says, I don't think it is the plaintiff's burden, then you assert it as a defense, the same issue. And you say, well, then we're defending on this ground in the Court of Common Pleas, practically speaking. And you can, for purposes of pleading, plead them both ways. Say that it can't meet the burden and it's an affirmative defense. The issue of whether it's a jurisdictional defense or an affirmative defense really is only critical if a litigant has lost their right to an appeal and you are trying to undo a judgment against the tenant, because at that point you have to then argue that it was an improperly rendered judgment on the surface of the complaint, and then you would have to argue it as a jurisdictional defense, because a court isn't bound to open up a default judgment unless there is a jurisdictional defect. So that's where it would come into play, this question. But otherwise, plead it all ways you can as a defense, and see how it goes.
Right, I agree. So that's the governor's order, and we'll just address quickly the question that was asked at the outset about, well, what happens in a case where there's both a non-payment of rent or end of lease term issue that is covered by the governor's order, and an eviction filing that claims another breach of the lease as grounds for the eviction as well. And as we said, I think the easiest way to attack that is when you're at the magisterial district court level where there's no pleadings, there's no motions. You just make the argument that we're here today focused on just the issue that is not covered by the governor's order, which is the other breach of lease. And if you can win on that, then you instruct the judge that the case has to be dismissed completely. But if the case goes, go ahead, Eileen.
I was just going to just make the point, however, that a lawsuit for, as we all know, the eviction cases have two causes of action, generally money and possession. And the actual suit for past due rent would not be prohibited. They could proceed with the actual money part, and as long as no possession is being considered.
Yeah, right. I mean, magistrates, I think, vary on how they view that, but I think Eileen's correct in her analysis of the law that you don't need to send a notice to quit just to file a lawsuit for breach of a non-payment of rent, as long as you're not seeking possession as your relief. So now, strategically on appeal, if you're dealing with a case that has those two separate grounds for eviction, one that is covered by the governor's order and one that's not, then I would highly recommend that the strategy be that you file preliminary objections to strike the allegations that are not that shouldn't be going forward because they're in violation of the governor's order or another tenant protection. And that's critical because I think we all know that when we're arguing breach of the conditions of the lease, those are tricky cases. They're hard to prove by the landlords. You can use your rules of evidence. You can cross-examine people. There's usually muddied facts. And so you want the judge to be focused on that, giving a yes or no answer to that question based on a preponderance of the evidence. And you don't want to leave open give the judge the opportunity to still evict because of the clear non-payment of rent issue. So you want to get rid of that in the beginning of the case in the court of common pleas. And that's why I would suggest preliminary objections. Eileen has graciously attached to the materials we'll distribute a sample preliminary objection on that basis.
There was a question that was raised that I was actually thinking of as I was talking a couple minutes ago, which was, so a landlord sues for non-payment of rent and possession and breach of other reason. And so the possession for non-payment of rent is knocked out. They get a judgment though for past due rent of $1,000. Is the well, actually, if it was just a non-payment of rent issue, so they knock out the possession, they get a judgment for money. Can then the landlord sue for possession based upon that non-payment of money at a later date, or is that res judicata? And my argument would try to be that it's res judicata, but my hunch is that no judge would consider that to be res judicata because this is a stay order. So all those types of arguments, I guess, would be told. I mean, the ability, if you're prohibited from doing something which you would have done otherwise, I don't see how a judge would say that you couldn't do it later.
Right, I agree. All right, so moving on from the governor's order to another protection, which is the Federal CARES Act eviction moratorium. Now, I'll point out that this expired already. July 25th was the last day that the CARES Act prevented evictions from being filed. But what we're talking about right now is cases that were prematurely filed. So same thing as what we just talked about with the governors, right? That this applies to non-payment cases. They shouldn't have been filed if the property is a covered property under the CARES Act. And so you can challenge those cases if they're still ongoing in the courts as not being properly filed. And I will, we'll point out, and we'll get to this, that there's, the CARES Act has that notice to quit provision. So if it's a covered property, the landlord had to have sent a notice to quit. 30 days is the period for that notice. And that couldn't have been sent until after the July 25th expiration of the eviction moratorium. So we're still in that period of time where, even though technically the act doesn't say you can't file, the notice provision prevents someone from filing. All right, next slide there. Eileen, do you want to talk about this sort of tricky hidden
Yes.
aspect of it?
So even though the CARES Act has the moratorium has expired, which means that even those properties that have federally covered mortgages, those types of properties, tenants could be sued for eviction now, or they couldn't be sued yet. First, you have to send the 30-day notice for non-payment of rent. There are certain of those properties that are federally covered that the moratorium is still in effect, and that's because of a different section of the CARES Act. The previous section of the CARES Act was section 4024, but this is section 4023, which really was meant to address relief for mortgage holders, for owners whose mortgages are federally covered. And what the relief was in section 4023 was to provide forbearance opportunities, for which therefore would delay the obligation on the part of the mortgage holder of those properties to have to pay the mortgage for a few months. And so section 4023 said that if any owner of a property, and this would be multifamily borrowers, like for the big, where there's big apartment units, when they have a covered mortgage, or even individual homeowners who have a mortgage, who we would, probably rent their homes to, individual tenants, single families. If they've applied for and received forbearance on their payment of their mortgage, then for the entire period of that forbearance period, the CARES Act prohibits evictions from those properties as well. And that goes beyond, that extends beyond July 25th, because in section 4023, any of those property owners could apply for forbearance and receive forbearance through December 31st, which meant that if you applied on December 30th for forbearance as a mortgage holder, owner of the property, and you got 3 months worth of forbearance, then that would mean that if you had tenants in that property, those tenants could not be evicted, could not even be given the 30-day notice to be evicted for non-payment of rent until 3 months later. That would be March 2021. So there is that aspect of the moratorium that it's not as well understood, and it's also very difficult to determine whether an owner is subject to that moratorium. In many cases, if it's for multifamily, and we'll talk about how you find that out, whether multifamily borrowers are subject to, are federally covered under the CARES Act. But even so, you still have to try to find out whether they obtained this forbearance relief. There's a couple other slides, I don't know if they're next, about there's even an extension beyond Yeah, so there's even an extension beyond those original 90-day periods as well. And these are agency extensions. HUD issued a notice earlier this month, which gave for multifamily properties, not single family properties, for multifamily properties, they are offering extended forbearance opportunities. And it's not specified the length of time in which those properties could receive that forbearance. Individual decisions being made on that. And then the Federal Housing Finance Agency, which regulates Fannie and Freddie mortgages, gave an additional 90 days forbearance opportunities. So so the owners have to apply for those extended forbearance, but if they do apply for those extended forbearance opportunities, then throughout the entire forbearance period, again, when the owners are not paying their mortgages and don't have to, they are also prohibited by those agency procedures now not to evict at all for unpaid rent during those extensions. So it's critical that that whenever we are faced with an eviction case where we determine that that property is Fannie or Freddie or FHA mortgage, or that those mortgages, that information needs to be ascertained whether or not that extension, that whether or not the owner is obtaining the forbearance, and thus the argument is that they're not allowed to evict. And then the slide indicates that there are actually particular requirements for repayments of rent to those owners who have obtained that forbearance. That the CARES Act no late fee charges or penalties continues, and that they cannot require a lump sum payment from the tenant until after the owner has repaid the entire past due mortgage payments that they weren't paying for during the forbearance period. So we're going to need to be watching out for those claims that might be improper under these particular provisions.
Yeah, so section.
I'm sorry. Dan, I'm sorry. So sorry. This is Kelly. I have to launch the first of the CLE question boxes. Attorneys on the webinar are messaging me privately, and they're very concerned that they haven't seen anything yet. So that will be up for 2 minutes. All attorneys, if you're requesting CLE credits, please respond. And I did have a question come in to me that was sent to me privately. If you'd like me to read that to you before you begin your other slide.
Sure, yeah, go ahead.
What if they filed now and only claimed non-payment for pre-pandemic with possession? Would that be a way for landlords to get around the order?
I'd say no. Well, is this I'm thinking no under the CARES Act, and actually under the governor's order, there's nothing in either of those documents which restrict the application of those stays to rent that became due only during the pandemic or since the pandemic.
Thank you.
Yeah, that's splitting a fine hair. I think the landlord's out of luck if they didn't file that lawsuit before the CARES Act took place, or the governor's order went into effect, or the court's prohibitions went into effect. I was just going to sum up what Eileen's saying is that there's this tricky section 4023 that really does extend the prohibition against filing evictions for non-payment of rent under federal law quite some time into the future if the property is connected to one of these mortgages that is getting a forbearance. So that's just something to keep a heads up on if you're able to figure out that is actually happening. And we'll speak a little bit more to that once we get to the affidavit requirement that is new to landlord-tenant filings.
Yeah. So just very
Right.
quickly, then I just want to add those prior two extensions, those dealt with only multifamily properties. There are two agencies, the VA and FHA. For those types of mortgages only, they've administratively extended the eviction moratorium through August 31st. There's a little bit of a debate about whether this eviction moratorium, so this would be for like owners of a property that have an FHA mortgage. There's a little bit of a debate that maybe these administrative declarations, which are quite clear, it says no evictions, was really intended to apply only to the owners who might be evicted from the property, but it's not in the law, and it's not in these declarations. And actually, I don't see how they could be considered evictions, because you can't get an eviction until you've already been foreclosed anyway, as the owner. So, but anyway, these two, VA and FHA, I think there's a good argument that the moratorium against evictions from single family homes, if they're mortgaged by VA or FHA, extends through August 31st. And that's the FHA declaration.
We have another question.
Yeah, I think this is a good time to answer some of these questions before we move on to notice to quit.
If the lease states that the notice requirement is waived and an addendum of the Landlord-Tenant Act is attached to the lease, but the tenant never received that addendum, can it be challenged that waiver of notice was not properly executed? And what is the standard, if any?
I don't think the standard is that they have to attach the notice. They have to attach to the lease or provide the tenant with notice of what the Landlord-Tenant Act says. I think if the lease waives note is written if it's written in the lease that it waived notice and the tenant executed that lease, then the landlord's going to hold the tenant to it. And I think the argument, it would be better served to make the argument that it was unconscionable than to say that because the tenant wasn't aware that the statute allows for waiver, that it shouldn't be enforceable.
Thank you.
I just want to say, somebody said, can you make the full screen? If you can just drag the photos to the right, you'll be able to enlarge the slide. Okay, Dan, you want to go on any of this?
Yeah, sure. Sorry, let me close the question box. As the pandemic continues to rage, quite frankly, but the statute's timeframes are starting to fall off, is the notice requirement under the CARES Act. Because that notice requirement, as currently written into law, does not expire. And that's a 30-day notice to quit, which is much longer than what is provided for under the Landlord-Tenant Act in this state. And it's longer for what's required in most HUD regulations and leases for non-payment of rent cases. So it's a significant change for landlords to have to adjust to. And I think you'll find that lots of them won't be sending the notice or will not be sending an actual 30-day notice. And it's just the same argument that you would raise if the notice in Pennsylvania, in the lease was not waived, or, any other lease requiring notice that's not been provided. You can argue that it's either jurisdictional or that it's condition precedent to, defaulting on the contract and moving forward with court.
If you go back, the other part of that, which is litigants, advocates are going to try to argue, and we urge people to try to argue that notice to quit, in contrast to the moratorium provision of that part of the CARES Act, is not the notice to quit requirement does not limit itself to non-payment of rent cases. And even though it's maybe a negligence or an error, that the law doesn't, that provision of the law doesn't say this 30-day notice to quit must only be sent to non-payment of rent cases. And we would argue and urge people to argue that it is required for every type of an eviction case until some other court says no.
We have from Don Merritt says, as to waiver of notice to quit, I don't think that you need to argue that it is unconscionable. There's a large body of PA case law holding that a waiver of a right, even in civil law, needs to be knowing and voluntary. Please follow up with citation of these cases.
Okay.
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 Yeah, I have to get that out then later. Thanks, Don. Yeah, I'm not going to get out of this screen and go look for those cases on my files. But I guess Don makes a good point that, maybe, and I guess that's what the question from Daniel was trying to bring up, was maybe that there's a lesser standard than going full unconscionability. And, if the waiver provision doesn't have the tenant's initials next to it, if it's not bold and in a part of the lease that can be seen, if it's not in the language that the tenant, negotiated in or speaks and reads, that, if the tenant doesn't read, like these, you could argue that those are not knowing waivers of someone's rights, and that because it's a right, the landlord who wants that contractual provision to take away that right has to go an extra step. So all right, Don, we'll try to get some case law out on that as well.
We also have another question now. Can you address the exception to stay in governor order when property owner has agreed or not agreed to participate in CARES rental relief program, i.e. application has to have been approved and owner received money or still in process of application?
Yeah, that, the CARES Act, the PA CARES Act is being run by, rental assistance program is being run by PHFA, and their regulations are not specific about that. But I certainly think you're not going to find, I don't think there's anything in the law, in the governor's stay order that says that pending an application, my stay applies. But the stay order does say that if you've received rental assistance, I believe it says if you're receiving rental assistance, then the stay order doesn't apply. I guess the argument could be made is that until you actually receive it, the stay order applies. But I also suspect that no judge in this state will agree to issue an eviction order if there's a pending PA CARES Act application.
Thank you.
Mind if I chime in? So
Yeah.
the CARES Act application, actually there's three applications, or there's three forms, three parts that need to be filled out to an application. And one of those is a landlord application where the landlord makes certain promises, certain statements. And one of those is that the landlord will accept that rental assistance in full consideration of everything that's owed, and that the landlord will not file to evict that tenant for 60 days after, until 60 days after the last covered payment is due. And so there's this promise in the application itself from the landlord not to evict. And so if you run into a case like that, I would take that landlord application and use that, raise that with the judge. And like Eileen said, that is, there's, no judge is going to, give the landlord a loophole after they make this promise not to evict. No judge is going to give the landlord, it's extremely unlikely that a judge will give the landlord a loophole to move to evict while the application is pending and before the assistance is actually received.
There's that. Okay, so
Okay.
you want to take it, or I'll take the legal charging of late fees. This is kind of, it was specific for those 4 months between March and July. The landlord is not allowed to charge late fees or penalties or any other charges. I think advocates have argued that that should include attorney's fees. I think if the attorney's fees are being claimed because it's in the lease, you could argue that that also is not permitted for any of those, for charges arising during that moratorium period. And then for those situations where the forbearance also has extended the moratorium, then that whole period of not being allowed to charge late fees is included.
Yeah, and the reason I included the quote from the statute here is because I guess there could be some ambiguity in interpreting this as to whether now that the 120 days has expired, the landlords can retroactively charge people who didn't pay their rent during that period, late fees and other charges. I disagree. I think that that's against the intent of the act, and that it shouldn't be read that way. And in doing so, reading it to say that at no point can you charge someone late fees for not paying during that 120-day initial pandemic period opens up, I think, a lot of landlords to counterclaims and to disputing the late fees that have been charged, because we know most landlords have just automatic late fee charges in their rent ledger programs. So I would urge people to scrutinize the ledger for those 4 months to see if there was illegal charges, and then turn that around as a counterclaim for a Fair Credit Extension Uniformity Act violation that can that can come into play, particularly if the person had to pay it, incurred some sort of expense because of those charges.
We have some more questions. In a private landlord-tenant case, if the lease provides for a shorter time period than what the law allows, can the landlord get away with this?
The landlord gets away with whatever the judge lets it, but that's against, in our interpretation, it could not do that. That would be improper.
Yeah, the Landlord-Tenant Act in Pennsylvania does allow for waiver or the lessening of the notice period. But the CARES Act doesn't have anything in it that says that. It just says 30 days. So no, I don't. If you're applying if the property is covered by the CARES Act, then it doesn't matter what the lease says, whether it waives it or shortens the time periods. It's a 30-day notice that's required.
And I think, and the governor's order as well, it's only if there's a complete waiver of that notice that's
right.
where.
Yeah, that's probably a better point. The governor's order applies.
Okay.
I guess the time periods they could be shorter under the governor's order, but they wouldn't start to run until September 1st.
Right.
Okay, next question. What is the consensus on whether the landlord accepting CARES funding means that they can't use other funding to make up any difference between monthly rent and $750? I have heard different things from PHFA.
We let Bob answer that when he talks about that part of it.
Yes, yeah, we'll get to that later.
Yeah, so let's try to move more quickly through our section, because I want to make sure there's plenty of time for the rent relief and things like that. All right, so there's a new provision, a new court order that requires that when a landlord-tenant case is filed, it now must have completed and attached an affidavit about whether or not the property is covered by the CARES Act. This is new, so the affidavit is on the AOPC website. It's a fillable form. It'll be in the packet for you guys to check out. And it's used to help the defense and the judge identify whether or not the property is covered by the CARES Act. There is a box that says that the landlord has to check as to whether or not they've affirmatively run the property through the search tool for Fannie and Freddie. And remember, that's the hardest one for tenants and defense attorneys to figure out whether it applies, because it's not necessarily going to be on the mortgage. The landlord might not even know that that Fannie and Freddie are involved in some way, because that can happen after the mortgage is created, after that initial transaction. And those lookup tools require the social security number or other personal data for the holder of the mortgage. So the tenant can't just look it up by address, et cetera. So this affidavit is going to be critical in helping the courts and the tenants identify whether the property is covered.
So the order itself requires that on or after March 27th, all filings have to have this attached affidavit, even though the order was not signed until July 16th. There's no other explanation except this was just a negligent error on the part of the court. But at least for all cases which are pending in the magisterial courts or anywhere now, it still is critical. I think it would be meritorious to assert that the case cannot proceed if it was filed before July 16th until the affidavit is supplied. If you want to do it that way, if you choose to litigate that way, or else, for certainly any cases filed on or after July 16th, they have to have, there's no excuse for not having it attached it. Some people have questioned whether you can undo judgments that were already issued. I think that would be a steep road to climb on that.
Yeah, I agree with Eileen. So you've got the possible defenses that the case was filed prematurely, that the case was filed without the proper notice, and that the case, that the affidavit was not included. We recommend that you, at the magistrate level, that you just go ahead and assert these directly, and then if it doesn't work out, we highly recommend a 10-day appeal and taking these issues up in the Court of Common Pleas. There might be a little bit of complication with the appeal process and jurisdictional issues. Once you take a de novo appeal, some courts have held that the jurisdiction is whether whether the filing date of the case sort of becomes the appeal date as opposed to the magistrate filing date. But I don't think that's not appellate law. And I think you have, by appealing, you have all your options at your disposal, including the lengthy process that an appeal can take that you're preserving for the tenant. However, as we've mentioned earlier, if you don't get the appeal taken in 10 days, but you think that the record is clear that the judgment was in violation of one of the defenses we've raised, then the writ of cert can challenge jurisdictional issues at any time. It doesn't have to be within 10 days or even within 30 days. So if you feel like there was a case that was filed prematurely, I think that's a good avenue to challenge that after the appeal period is run, is through a writ of certiorari to the Court of Common Pleas. Eileen, do you want to take this one up?
So there's, even though now these landlords have to file this affidavit in Pennsylvania, at least until August 24th, it's still no proof that the CARES Act moratorium doesn't apply for the reasons that Dan was talking about. And we really won't necessarily have adequate assurances ourselves just because the landlord has filed the affidavit that it's accurate. So it leaves cross-exam and discovery after, which is not available in the MDJ courts, but cross-examination as a way to try to figure out, to challenge the veracity of the affidavit. And so I think the next slide has some, the next couple of slides have a bunch of cross-examination.
Let's skip that. You can look back at the slides. There's some very good questions broken down by whether it's a small property or a bigger property. And you can use those questions in your discovery requests. It's a very good way of ascertaining whether or not the property is actually covered or not. But we're behind here, so let's move on. Yeah, and then these links are the links that you'll use to try to find out whether or not the property is covered yourself, and whether, what the landlords can use. I'll also point out that in the materials, we have a bench card that explains the CARES Act and its application to judges. And the second page of that bench card is, all about how you figure out whether or not a property is covered. So you can refer to that when you're trying to do your own pre-hearing investigation.
So the next slide has to do with, the next couple slides have to do with, we're going to be negotiating a lot of payment plans over the next several months, many months. And and the question is how to do it so it doesn't hurt the tenants. The worst possible, and so the next two slides, which you can look at, I'll go over really quick, I'll pass over, but is try to get an agreement that keeps the past due amount of rent separate from paying the current mortgage, to make sure that on the books that you try to get the landlord to agree that the client is current, just like a forbearance agreement would have been, is with mortgages. Not to add on interest or fees when the arrearage, on those arrearages while a payment plan is being issued. But most importantly at all, try to prevent any agreement that a judgment will be entered automatically if there's a default, or that a judgment is entered initially that will not be executed except if there's a default, or not include a waiver of any new notice to quit if the tenant fails to comply with the plan. Those are so important to, especially now where we know that because of all this computer access to eviction cases, it even prevents tenants from who need to move because of being evicted. It prevents them from finding new housing. And so this idea of an easy way for a landlord to obtain an eviction by expediting the process of getting that judgment, we should avoid, I think, at almost all costs. And that's what these those factors discuss really. So we can go on.
Okay, so I'm going to move through these two sections. I guess this section a little quickly, largely because I think the most important part here is actually in the materials that'll be provided to all the attendees. But yeah, Dan and Eileen referenced, affirmative claims counterclaims that we could bring, or claims that we could bring against a landlord or a landlord's attorney for violating some of the provisions in these moratoria. So I'm going to start with Fair Debt Collection Practices Act. This is federal law. This applies to landlord attorneys, not the landlords. And so some of the places where we really see this come up, I think, is especially with the provisions restricting the collection of late fees, or with notice provisions. So we have right here, right, that we can't, landlords can't make any false representations about the character, amount, or legal status of a debt. So this can arise when a landlord is trying to collect past due late fees, late fees that wouldn't be allowed under the CARES Act. Or also here, false representations about false representations or deceptive means for trying to collect or attempt to collect a debt. So once again, right, not allowed to be sending a notice here. Is the landlord or the landlord's attorney, and landlord's attorney in this case, taking actions against that are prohibited by the moratoria or by the CARES Act, that would prevent them from collecting a debt. And there's and this is strict liability. You don't have to show that they had some intent to violate these moratoria. And this is, I think, especially important here, that the Fair Debt Collections Practices Act has a carve out for clerical or factual errors. So you just say accidentally mess up the amount, mistakenly send someone a notice when you weren't supposed to, and it's very clearly just it was an accident. But it does not apply to mistakes of law, and so under this, the landlord's attorney does not have the excuse that there are a lot of things changing right now. I just didn't keep up. I didn't mean to send it. I didn't know that I wasn't supposed to send it, or I didn't know I wasn't supposed to be collecting these late fees. Yet that's unfortunately for them, it's not an exception under the Fair Debt Collections Practices Act. So I think it's one of the things that landlord attorneys need to be very careful about. So one of the things that we've seen is that this actually works fairly well. Bringing this up works fairly well as a preventative measure. So here at CLS, we send out a couple of letters to the larger landlord attorneys in Philadelphia, and those examples of those letters are attached. But one of those is directed toward the CARES Act specifically, so it covers a lot of the material that we already covered, and some of the things that they'd be restricted under. Landlord attorneys would be restricted from doing under the CARES Act, and then the other ones under Emergency Housing Protections Act, which is very specific to Philly. But we're including these. We're including that one also, largely because of the language around it. It demonstrates how the restrictions connect to the specific parts of the act. And we have heard from some landlord attorneys that this has made them be much more careful. They open themselves up to liability. It's not their under the Fair Debt Collections Practices Act. It's not their clients that are opening themselves up to liability. It's them. So they need to be careful. They need to stay on top of the law. And there's a great example from the Public Interest Law Center, had a suit against Levy Law here. And so there's this link here. If you want to look to see what example complaint under Fair Debt Collections Practices Act looks like. There's beautiful example that we cite to also in the letters. it's something that when we remind the landlord attorneys that this has happened before to some of your colleagues, so you should be careful, they take it more seriously. Other set of laws, state laws. Once again, I'm going to move pretty quickly through this, but I think the most important parts are, can't make any false representations. Oh, right, the state law. This one applies both to landlords and landlords' attorneys, but can't make any false representations about the amount, legal status of the debt. Once again, we have restrictions on late fees. If you see the landlord trying to collect late fees that they're not supposed to, this is one of the key areas where you can make these counterclaims. So once again, I think, the most important thing actually is to have some examples. So Eileen has done this before, filed these counterclaims before and had a beautiful example of how these counterclaims should look like. And so that's included in your materials. But so I think some of the things to keep in mind is that if a landlord or landlord's attorney, right, is opening themselves up to liability, they're going to be much more, or they should be much more careful about whether or not they're filing these evictions improperly. Because once these evictions are filed, our clients are permanently harmed, right? Our clients have a much harder time finding housing after an eviction's been filed, regardless of the outcome of that case. And so one thing that we've seen in our practice that has been very successful is sending these letters to landlords and landlord attorneys, notifying them that they could be opening themselves up to liability under these sets of federal and state law. That way, while we're still in some of these moratoriums, we don't end up with improper filings, and they'll also be more careful immediately after the moratorium with regard to these filings.
All right. Okay, thanks, Vic. I've already explained what regional housing is, so skip to the next slide. Okay, so I'm going to cover really quick just the Pennsylvania rental relief program. There's some other rental assistance programs available throughout the state, and feel free to contact me offline, and I'd be glad to discuss those with you. But in the interest of time, I'm just going to cover the RRP program. So essentially, the state legislature has, Pennsylvania received an allocation of CARES Act funding, and the state legislature has turned around and allocated $150 million statewide for rental relief. It is administered by PHFA, but you apply at the county level. So each county has an agency that is accepting applications. Pennsylvania, PHFA also accepts online applications, but only for Philadelphia and Allegheny County. Every other county, you have to contact the agency in your county and apply there. And even in Philadelphia and Allegheny County, you should really work through those agencies. If you want to find out what agency is administering this assistance and taking applications in your county, there's a contact list. There's a URL on the slide for a PHFA contact list. And so just, check that website and look at your county, and it'll give you contact information for the agency that is taking applications. As has been mentioned, and as I'll get into in a little bit more detail in a minute, there's a cap on rental assistance. So it is the lesser of the amount of the monthly rent, or $750 per month. and it can be provided for up to 6 months. Any 6-month period between March 1st and December 30th. And the landlord has to, waive, the right to collect any remaining amounts due over and above that $750. If the rent exceeds $750 a month, the landlord has to waive the excess amount. And there are some strategies for dealing with that if the landlord doesn't want to, isn't willing to waive that we'll get to in a minute. The application deadline right now is September 30th. So, that's coming up. That's only 2 months away. This is not a whole lot of time to apply. Who knows? Maybe that could be extended. We'll see. There may be an extension in the federal law that is being considered, and if that passes, I'm sure, the state law may be extended as well. Next slide, please. To be eligible for this assistance, household income has to be at or below 100% of area median income, and either the applicant has to be unemployed as verified by the Pennsylvania Department of Labor and Industry. After March, it has to become unemployed after March 1st, 2020, as verified by the Department of Labor and Industry, or have to lost more than 30% of household income since March 1st, 2020. Those are alternative requirements. AMIs, if you don't deal with HUD area median income, you can find those at the HUD user website, and there's a link to where you can find AMIs for your county. And so a couple words on the $750 a month rent cap. No, go back, please. One way around this is co-tenants can apply separately or can possibly file joint applications. So essentially, if the way this restriction applies, it really favors single roommates as opposed to, say, single parent households with children. The way this is structured, and part of this is statutory, most of this is statutory, is household income has to meet that 100% AMI limit. But as long as the house, and so if you have more than one tenant in a household, all of their income is combined in determining whether they meet that limit. But each tenant can be separately eligible based on the other criteria. And so if there's more than one eligible tenant, more than one eligible lessee in the household, they can each receive up to that $750 a month cap. And so the first question to look at, if you're bumping up against a $750 a month cap and you don't think the landlord will waive the remainder, is there more than one lessee in the household? So look for that. If there is more than one lessee in the household, try to determine whether they're separately eligible under this under these criteria. But if you are in the more likely scenario, if your client is, say, a single parent household with children in a larger unit, that tends to cost more than $750 a month, this really doesn't apply. And so there's other ways to get around that. One way is, the question that was asked, can rent be, can other forms of rental assistance be provided? And the short answer is yes. I'm going to, here is in the chat a link to PHFA's FAQ on the issue, and this is one of the questions that they answer. one of the questions that's asked, and their answer is yes, you can use other forms of rental assistance. The problem is the timing. Any other rental assistance has to be provided before the application is submitted to PHFA. Once that application is submitted, it contains that landlord waiver, that landlord promise to forgive any amount remaining over and above the $750. And so it's really a timing issue in some counties. So I know in Allegheny County, the agency that provides RRP, that administers the RRP program, also administers other forms of rental assistance, and they can work out that timing issue themselves. In Philadelphia, it's two separate agencies, and the applicant has to negotiate those silos. And so in other counties, I'm sure it's like that as well. But if you have any issues, any questions around that, I'd be glad to work with you. Please contact me offline. Be glad to help you figure out what other rental assistance might be available in your county, and who is it that administers that assistance, and how you might be able to navigate this. And then finally, Vic is going to talk about some other strategies for getting around this $750 cap.
Kelly, did we want to do that last poll real quick? Because I
Yes.
think we're at time, and then we can.
Yes.
We only have a couple slides after that.
Yes, people are getting anxious. So for
Yeah.
attorneys participating in the webinar, if you're requesting the 1.5 CLE credit for your participation, please respond to the question now. You'll have 2 minutes to do so. And Vic, please continue. Thank you.
Well, yeah. So just as Bob was just saying, right, with regard to rental assistance, the issue is timing. But then this also applies to a payment plan. So what we've seen is that an ongoing payment plan doesn't work, right? Because an ongoing payment plan would happen, has payments after the landlord has already agreed to forgive that rent above $750. But a plan where the tenant prepays maybe some of that difference. So an example I just had a couple weeks ago, ongoing rent was $800. Landlord was really a stickler about that last $50. And so the tenant agreed to pay $300 up front to cover that difference of $50 each month. And so if you run into a landlord that's being obstinate, that's one possibility, is to have a payment plan where if possible, the tenant prepays that difference. The other thing that we've seen is some of these local agencies have been willing to call landlords themselves to try to convince them to take the money. And sometimes having an outside force, an outside agency can really help with us. Landlords may not trust us, but they may have an agency. Say for example, right here in Philadelphia, right? It's PHDC that's administering it, and yeah, we've heard of PHDC giving landlords calls to try to convince them to join the program, and we've heard that they've had pretty good success with that. So I think the three takeaways are rental assistance works, just as Bob said, as long as it's done up front. Payment plan works, once again, as long as it's up front. It's all about the timing. And then talk to your local agencies. Sometimes they'll be able to convince the landlord to enroll in the program if you end up running against a roadblock with the landlord. And then Dan, did you want to have like a quick comment on this? I don't know if you're muted, Dan. Let's see. There we go.
There we go. All right, so I just wanted to point out that in response to the pandemic, the Attorney General's office has actually prioritized complaints about landlord-tenant issues to its consumer hotline. And we've been told that an investigator or an attorney will try to investigate or mediate these complaints very quickly putting them above other complaints at the moment, as they work for, most of their staff works from home. And my experience has been that this is true. I particularly point out that, with all these tenant protections, I think there's been an increase in illegal evictions, landlords trying to go outside the court system to get their clients out. But the AG's office has been very quick to respond to those complaints, and they're not requiring sort of multiple complaints to build up about one landlord before they'll take action. They're actually investigating and getting it, giving calls out. They're not bringing cases, but I think a lot of the times their presence in the situation can prevent an illegal lockout. So I encourage you to direct your clients to call that consumer hotline. And then if you need to get in touch with the AG's office, reach out to myself or Matt Rich. I think both of us have some contacts that have been willing to, listen at least and try to direct a request quickly if need be. Well, since there's some dead silence, I'd like to just take at the end here an opportunity to encourage people during the pandemic to continue to advocate for new tenant protections and to continue to enforce the tenant protections that have been created in response to the pandemic. That's very important that we help out people who are facing eviction, and feel free to reach out to CJP for the rest of the state and CLS in Philadelphia, so that we can try to collectively monitor what the problems are that we're seeing in legal aid across Pennsylvania, and get that information, that data, to the people who could make a change. And then I'll also advocate that we continue to push for new developments in the law through the courts that might have more sympathy now that everyone is going through a pandemic, that this is affecting people, on all spectrums of the economic scale. The idea of pushing for better payment plans than we have in the past is a good, is important. The idea of arguing things like unconscionability or improper waiver of your rights as a tenant, will probably have more traction now. And if we can get some decisions on this now, that can propel tenant rights long into the future. So I just encourage everyone to keep doing that work.
Just to build briefly off of what Dan said, that I do encourage for things that are being decided in a way that we don't think they should be decided. Additionally, phillytenant.org has a lot of resources that are related to laws that are passed in Philadelphia, and a lot of it are forms that have been put in place. And although the law itself may not be applicable in your jurisdiction, sometimes if you just present a landlord with a form that's easy for them to digest and fill out, you might get them to agree to terms that are more favorable for your client. So I encourage you to look for those resources as they are available, and we're always available to help in any way.
Yeah, I want to add to that really quickly. So Kelly has all our contact information if you don't. And I would encourage Kelly to provide our contact information when she sends out the slides in the materials. And so please feel free to, speak for myself at least, feel free to contact me if you have any questions about rental assistance. And I'm sure others on this panel would say the same.
And we should go without saying that hopefully every one of the lawyers on this training has signed up to be part of the Plan Housing Group, where lots of questions can be raised and answered and shared with everyone else who are surely experiencing the same questions and issues. So.
I'd like to encourage everyone to check out the materials. We that are going to be distributed to all the attendees. We have pages and pages of materials, sample counterclaims, right? Sample letters, sample defenses. Like it's, I think coming out of this webinar, I imagine that the most useful part are going to be the materials. So please make sure to go through and at least peruse the materials. That way, when later on you're thinking about how to draft a certain defense or how to draft a certain counterclaim, you know that you have a resource to go and pull that from.
Wonderful. Thank you everyone so much. We appreciate our presenters for being with us and taking some of their time to put these materials together. So I wish you all a good day. Thank you.
Thank you.
Thanks for arranging this, Kelly.
Sure.